Hello everyone, this is Professor Azim Khan Pathan. Today I will be speaking in the context of the law of fundamental rights and reads this particular subject. Indeed, this is very important area of contemporary India where the jurisprudence, more specifically constitutional jurisprudence, is emerging. And in the context of constitutional jurisprudence, indeed fundamental rights and reads this particular paper becomes vital. Today, in this introductory talk and introductory module, we will be talking about impact of legal positivism and also the impact of natural justice on the interpretation of fundamental rights. We will be talking about more specifically in the context of how exactly judicial interpretation, Supreme Court's judicial pronouncements, Supreme Court of India and its pronouncements in the first phase of our Indian judiciary after independence impacted with the legal positivism. So in that context, we have to understand the very basic background of legal positivism. If we go back in the jurisprudence, more specifically the John Austin's, Jeremy Bentham's ideology in the context of legal positivism, they have stated, more specifically John Austin has brought the idea that how law has evolved, how law is ultimately man-made law, and how it has to differentiate it from morals, ethics. In that context, legal positivism has talked about that what is ultimately law, how exactly law is posited. So from that perspective, John Austin has brought the idea in the context of legal positivism, and he said that law is nothing but the command of the sovereign. Law is nothing but the command given by the sovereign, and it is bound by the subjects. Subjects they have to follow, and it is backed by the sanction. So this particular approach indeed in the initial phase of our independent India and judiciaries, in the decade of 50s and 60s, reflected in the judicial pronouncements. So in that context, we have to see how the fundamental rights, whatever were guaranteed in Indian constitutions, those were indeed influenced, especially by legal positivism. So going ahead in the context of legal positivism, very first important judicial pronouncement that is A.K. Gopalan versus State of Madras in the year of 1951. This particular judicial pronouncement is the best example for the entire constitutional jurisprudence, how exactly our Indian judiciary was influenced indeed with this legal positivism. Indeed, in A.K. Gopalan, the interpretation of our Indian constitution that has been, taken into account from very narrow angle, only taking into consideration more specifically whatever those are provided in Article 21. When the question it came in front of Supreme Court in A.K. Gopalan case versus State of Madras, that whether this Preventive Detention Act under which A.K. Gopalan he was detained behind the bar, whether this particular Preventive Detention Act deprive A.K. Gopalan from his personal liberty with fair procedure or not, whether it is based on fairness or not. So in that context, A.K. Gopalan argued, contended in front of Supreme Court that there is clear-cut violation of Article 21 of Indian Constitution. At the same time, there is clear-cut violation of Article 19 of Indian Constitution, and then besides that, Article 14 of our Indian Constitution. Indeed, he has brought a new interpretation saying that for procedure established by law for depriving a person from his personal liberty, the law should be fair, law should be reasonable, it should be based on natural justice. Indeed, this Preventive Detention Act 1950 does not contain fairness, fair procedure, and the opportunity of hearing, which is one of the important core values of natural justice. But here, indeed, the Supreme Court of India and majority of the judges 4:1. More specifically, headed by Justice Patanjali Shastri, he stated that we are there to interpret the Indian Constitution and Article 21, whatever it has been given in Indian Constitution. And Article 21 provides that the person's personal right and liberty, it can be deprived only if there is existence of the law and that particular law is establishing the procedure. Here in this particular case, the Supreme Court of India had stated that the procedure that has been properly established by the Preventive Detention Act, and that has to be complied, and that has been complied by the lawmakers and by the enforcement agencies. So we are not there to see the other important, the contours like vague principles, abstract principles of natural justice. We are not there to interpret at the time of seeing whether Article 21 is violated or not by any legislation. We are not there to see Article 19 or reasonableness of Article 19, because these different articles are totally and mutually exclusive articles. When the question comes with reference to interpretation of Article 21, we are there to only see the Article 21. And Article 21 has stated that procedure established by law, if it is there, then personal liberty and life, it can be deprived from the side of state. So that has been complied. So this particular approach of 4 judges in this 1952 case of A.K. Gopalan, it was purely based on legal positivism. It was purely based on the literal interpretation of Indian Constitution. So in that context, we can see, with the help of judicial pronouncements, number of judicial pronouncements, including this A.K. Gopalan versus State of Madras case, how exactly in the initial phase of our Indian independence and after Republic, after 1950, we can say that our Indian judiciary, they were interpreting the constitutional provisions more specifically from very narrow perspective. And this particular ideology of English jurisprudence, that was influencing the judge's mind in the initial phase of our Indian Constitution's interpretation. And accordingly, our fundamental rights law also evolved. Our fundamental rights also got influenced by legal positivism. But we can see further the development, how exactly at a later stage, other important contours including human rights, including socialism, those have also influenced this fundamental right, or more specifically, specific fundamental right and different fundamental rights which are guaranteed in Part 3 of our Indian Constitution. So from that particular, perspective or window, when we have to see how the law of fundamental rights grown in our Indian Constitution or for our Indian governance, so in that context we have to also understand how the natural justice or principles of natural justice were also influencing the law of fundamental rights. But to your surprise, you will also come across by a very specific and critical approach of Justice Fazal Ali in this 1952 case in A.K. Gopalan, where he had given dissenting opinion against those 4 judges headed by Chief Justice of India, the then Chief Justice of India, Justice Patanjali Shastri. He was supporting and saying that indeed the natural justice principle that is already present in our Indian Constitution. We should not see every article as a mutually exclusive article, because reasonable restrictions which are guaranteed in Article 19 of our Indian Constitution, those reasonableness ultimately are based on natural justice principle only. Indeed, we have to see that when personal liberty is being deprived by any particular legislation established through establishment of procedure, then that particular deprivation of liberty should also see certain reasonable restrictions which are guaranteed in Article 19, Clause 2, Clause 3, Clause 4, Clause 5 and Clause 6 of our Indian Constitution. Because freedoms guaranteed to the citizens of the country, those freedoms including freedom of speech and expression, including freedom of movement and freely movement within the territory of India, those freedoms are ultimately the facets of personal liberty. Those freedoms are ultimately facets of Article 21. So, Article 19 freedoms and Article 21's personal liberties are not mutually exclusive. When there is questions of deprivation of personal liberty at that particular time, the judges, that particular time, the system, they have to also look into in other article. So we cannot take this particular stand that every article is mutually exclusive. Article 21 is totally and mutually exclusive. The question when it comes with reference to any legislation, with whether it is establishing the procedure for depriving the persons from his personal liberty or her personal liberty, and then whether that particular legislation, whether it is complying with Article 19 or not, this particular, the interpretation, narrow interpretation, which is made by these particular majority judges in this A.K. Gopalan case, it is not exactly a viable interpretation. Because Article 21's personal liberty is also connected with the freedoms which are guaranteed in Article 19. So, those personal liberty or that particular personal liberty, when it is being deprived, at that particular time, the legislature, they are bound to see those restrictions or that kind of deprivation of personal liberty should also comply with Article 19, because reasonableness and reasonable restrictions are also one of the important facets of natural justice. So that was specifically stated by A.K. Gopalan, and more specifically in A.K. Gopalan case from the side of Justice Fazal Ali, who was providing the dissenting opinion. So see, you can find the seeds of natural justice was also already present in 1952. But in 1952, the majority of judges, they had rejected this natural justice principle and interpretation of natural justice principle, and even saying that we have not accepted and adopted this due process clause of American legal system, which was also one of the facets of natural justice principle based the process. Due process clause inclusive of substantive due process and procedural due process. So based on due process clause of American Constitution, any legislation can be challenged before the court based on its substance, its rights, duties given in the legislation, at the same time based on its procedural fairness as well. But that is not case with reference to India, when Article 21 that had been inserted, originally Article 15 in the draft constitution, when this has been inserted, we have avoided this particular specific, the concept or specific, we can say the forum of due process, because history was behind that. When our constitution advisor B.N. Rao, he visited the America, and when he, consulted with Justice Frankfurter indeed he had, specifically suggested to our Constituent Assembly and our Constitution advisor B.N. Rao that you should avoid this particular due process clause in your constitution, because you have to march ahead with many developmental activities. Your government has to march ahead with many developmental activities. If due process clause will be inserted in our Indian constitution or in your Indian constitution, then in that circumstances, every day any legislation based on its procedure as well, it will be checked and challenged by judicial review. and then it would be very difficult for the successive government. They will be devoting their more and more time in litigating before the court. So instead of due process clause adoption in Indian legal system and constitution, you should, see other ways. So based on this opinion only, in Article 21, the words and the concept of due process clause that has been avoided and procedure established by law that has been accepted. But if you will see carefully in the dissent opinion of Justice Fazal Ali, he was saying that there is no question of due process. We cannot be restrained just based on saying that we have not adopted due process clause. And then we cannot say that natural justice principle cannot be seen or cannot be interpreted in procedure established by law. How come any procedure, oppressive procedure, if it is there, established in any particular legislation for depriving a person from his personal liberty and life, how can we justify that, unreasonable procedure? So we have to see that procedure should be reasonable, and that can be judicially reviewed. The legislation can be judicially reviewed because reasonableness, natural justice indirectly is reflected in other articles of our Indian Constitution. So this particular opinion in 1952, that was avoided, that was rejected. Why? Because legal positivism, it was prevailing. We had seen closely British legal system working and, inclining, the interpretation based on positivistic approach. That parliamentary supremacy, that whatever that has been given by the Parliament of British or British Parliament, that has to be obeyed, that has to be, followed as it is. That approach reflected in A.K. Gopalan versus State of Madras case. But you will find, at a later stage, R.C. Cooper, more specifically Menka Gandhi versus Union of India case, how beautifully natural justice principle synergy that has been, more specifically interpreted in Article 21. So we can see that natural justice principle, human rights based jurisprudence, slowly it was percolating in the minds of judiciary, and that was also reflecting in the interpretation of fundamental rights, and then more specifically, consequently, the law of fundamental rights was emerging in our Indian territory. So in coming session, we will also discuss how indeed this particular natural justice principle influence the entire constitutional jurisprudence. So thank you so much for listening this particular session.